should look at the totality of the entire record in deciding whether or not a specific assertion is clear and unequivocal. And while the state is correct that it is a totality of the circumstances review, it's a totality of the circumstances surrounding the request. And while the defendant asserts this numerous times, the original 5-4 denial, what the totality of the circumstances around that request, it is irrelevant what the portions of the record that post-date that request in terms of deciding whether or not that first 5-4 request was clear and unequivocal. Now, in terms of his pro se motions, these are pro se motions, and they should be given some latitude in terms of how he chooses to label them, I guess, in terms of the titling of his motions. But within the motions, he's reasserting his right to self-representation, and then he's stating on the record, I'd like to reassert my Sixth Amendment right, or I'm being forced counsel, so if I have to have counsel, then I guess.
May I ask you this? I mean, understanding that the defendant is self-represented, and applying that rule that you want to give the defendant some latitude, to, try to support the defendant in their ability to represent, advocate for themselves, advocate for their interests. And if we get back to the May 4th, even just looking at May 4th and looking at what the court did, denying without prejudice, if the goal and the interest was the issue with respect to getting discovery, and if the reason that that discovery had not happened was because of the state not getting the video that was the subject of the concern, and if the court tried to address the substantive concern, doesn't that seem to weigh, doesn't that seem to really address the underlying issue of what the court is supposed to do in giving the defendant's latitude, getting to what the actual issue is? That appears to be the issue.
Yes, so that is correct, where the trial court does have, ultimately the discretion to explore. But once there has been a clear and unequivocal request, the trial court does not have a right to investigate into certain aspects of discovery and whatnot, as long as it's a timely request. This is a situation we also saw in Braswell, which controls this case, where there is a clear and unequivocal request, but instead of canvassing the defendant about that request, they start to consult with counsel in the state about various matters of discovery, and ultimately that his conviction was overturned for that reason. As well as if we look at the 5-4, the initial assertion, it's clear that, right from the beginning of that proceeding, trial counsel comes out on the record, and that's the first thing he says is, my client has indicated to me that he'd like to represent himself. So it's clear that trial counsel understood that that was going to be how this proceeding would move forward. And then, the defendant then appears and says the same thing. And instead of canvassing him after that clear and stating, I'd like to proceed pro se, really can't get any more clear and unequivocal in terms of that request. And, and instead of canvassing the defendant after that, the trial court proceeds to discuss with counsel.
All right, thank you.
So the second prong to this court's analysis is that the trial court improperly failed to canvass the defendant once he had clearly and unequivocally requested self-representation. The third prong to this court's analysis would be that the trial court denial was improperly based on the quality of defense counsel's representation and the status of discovery. And lastly, the defendant did not waive his right to self-representation because once there has been a clear and conclusive denial, the defendant does not have a duty to continue to make fruitless requests for self-representation. And And even though it was denied without prejudice, if we look at the next assertion on 9/1/17, in that proceeding, the defendant explains, I've already asked for self-representation. If I could actually draw Your Honor's attention to page A154 of the appendix, starting right at line number 1 on that page 8 of the transcript, the defendant explains how he asked for pro se and was denied by another judge. The court responds, well, then that's the end of that. He asked to assert his Sixth Amendment right, and the court asked, sure, Your Honor.
Counsel, did you submit that portion, that transcript that references that denial of counsel in the appendix?
Which one, Your Honor?
The one that he's referring to on page 154.
Sorry, I'm not understanding.
You said that the request for counsel was denied previously by another judge. Is that transcript a part of the appendix?
Yes, that is it's part of the May 4th. So on A142 is the first page of that transcript. The actual denial would be on between pages 145 to 147.
So when you say that, you're referring to page 146, where it was denied without prejudice, though.
Yes.
Oh, what? Judge?
We may have lost.
Judge Elgo, I think the screen is split.
Yeah, I'm trying to figure out. I hit a button. Oh, there you are. Thank you. All right, go ahead.
Sorry, if you wouldn't mind repeating your question.
No. Go ahead. Go right ahead.
So yes, so it is denied without prejudice on. Let me see here. If I could just have a moment, Your Honor. It's on page 146. And that's with reference to the May 4th denial.
Okay, thank you.
And so ultimately, once there has been a clear and conclusive denial, there's no longer a duty to make continuous requests in terms of waiver. And ultimately, the defendant did not waive his claim at that to self-representation, in this case, based on that May 4th denial. The trial court, ultimately, the clear and conclusive improper denial in this case is structural error and requires reversal of the defendant's conviction in this case. And I'll reserve my remaining time for rebuttal.
All right, thank you. Very good. All right, Attorney Feldman.
Thank you, Your Honors. Lori Feldman, Deputy Assistant State's Attorney on behalf of the people of the state of Connecticut. Your Honors, the defendant did not make a clear and unequivocal request requiring the trial court to abruptly move into waiver canvassing mode within the legal meaning of clear and unequivocal request, which is a standard intended to safeguard the defendant's fundamental right to counsel, with a presumption against permitting a defendant unintentionally to waive that right. The defendant's claim turns on one statement in 1 out of 35 court dates of the defendant's, when, after complaining that Attorney Leaf was not doing enough to speed the process of discovery, which is a very common frustration of criminal defendants in our system, the defendant said, he's currently ineffective, I'd like to proceed pro se. According to the defendant, the trial court, regardless of its sense of what motivated this statement by the defendant and what his understanding of what was going on in the circumstances that led him to make that statement, was required to simply move into waiver canvassing mode and potentially have the defendant waive his right to counsel based on momentary frustration or lack of knowledge about the discovery process or who was responsible for the delay in getting the videotape, based on what the Flanagan court calls occasional musings about the benefits of self-representation, which Flanagan says are not clear and unequivocal requests, because the clear and unequivocal part of the request is not the words that are used. It is the demonstration that the defendant has really given this thought and should move into a canvas on whether he knows what he's giving up when he gives up counsel, as opposed to a colloquy with the trial court and an opportunity to explore what the basis of his frustration is, where the statement may not really be a statement of his permanent and thoughtful desire to give up the right to counsel. The words,
counsel, if I may. So so your view is, the state's view is that there's a difference between making a statement that indicates or suggests that they want counsel versus, I mean, really, how does a court make the distinction between the assertion and the musing? Because it seems to me that's somewhat of a fair, fine line. Is that not correct, or do you think that
it is? Yes, it is a fine line, and that's why that distinction is in the discretion of the trial court, with its firsthand opportunity, its situational sense, its opportunity to talk with the defendant, see what the frustration may really be based on. It is a fine line, and our courts want to err on the side of not jumping into a canvas on the moment when a defendant may be under the heat of emotions or frustration and may give up his right to counsel. I would point out that in this case, this defendant repeatedly did things in the heat of emotion that he later regretted and retracted. I will also point out that after the trial court in this case agreed with the defendant, the trial court did deny the request, but it told the defendant that it was denying the request without prejudice. The court told the defendant that he could bring up the request again if he wanted. And I think most importantly, the court agreed to the defendant's request to delay proceedings for just 1 week, have the next court hearing 1 week later to see what the parties would be able to achieve to accommodate the defendant's interests. And this was after the court explained to the defendant that his counsel was not at fault for the delay with the videotape, and that he, as a self-represented party, would not get it any sooner necessarily. And within that week, first, at the end of that week, counsel did file the motion to compel the state, which the defendant had been agitating for on May 4th. I think it's also really notable that within that week, a question of the defendant's competency came up. And although he was ultimately found to be competent, this is another indication of why it's really critical for the court not to have simply jumped on his statement, this counsel is doing nothing for me, I want to proceed pro se. Counsel had done a number of things for him, which the trial court encouraged counsel to state on the record on May 4th. And the defendant was very frustrated, and the court wanted to give the situation time to see whether it would develop into a deliberate and considered, clear and unequivocal request to not be represented by counsel, or instead whether this was frustration with this particular counsel or frustration with the pace of discovery or other things that should not land the defendant in pro se mode, representing himself in a criminal trial.
Attorney Feldman, may I interrupt? All of these rationales that you are offering, with respect to, the court, in what you're suggesting is it's the court's discretion here, right? And you're suggesting that before there is in fact a canvass, the court has some discretion to determine whether a canvass is actually warranted. Is that what you're saying here?
That is correct. And that the canvass has to occur after the court has assured itself that the defendant's request is clear and unequivocal, because the canvas is moving into a different mode, not answering, misguided concerns or momentary frustration. The canvas is moving into the different mode of whether the waiver of counsel is knowing and intelligent.
And some of the rationale that you're giving with respect to the court's exercise of discretion those are not what has been proffered by the court in this instance in May 4th. Is that what you're discerning from the record? Are you speculating that that's what the court was in fact considering in before it actually decided that it wasn't going to canvass the defendant? I mean, there wasn't really a determination, I'm not going to canvass, I'm just going to deny without prejudice, which is effectively the same thing. But I guess what I'm not clear about is whether or not the court was, whether there's any basis to believe that the court was in fact exercising its discretion in the way that you're attributing. And does that even matter?
The court did not make factual findings or place its thinking on the record, but there's no legal requirement that the court have done that. And in all of these cases, what the reviewing court does is to look to the circumstances to see whether the trial court's response appears to be reasonable under the circumstances. And I would say that the standard incorporates the requirement, this is in State versus Carter, that the trial court should, quote, weigh in the balance its obligation to indulge in every reasonable presumption against waiver of the right to counsel when the trial court does not treat a statement as a clear and unequivocal request that requires it to move into waiver canvassing mode. Some of the trial court's thinking is apparent from the record. It didn't state why it was doing what it was doing, but the trial court did have defense counsel enumerate the steps that defense counsel had taken on the defendant's behalf. The trial court did explain to the defendant more about the discovery process in terms of that this videotape was in the state's control, not defense counsel's. And the trial court also explained to the defendant that all of the other things that the defendant said he wanted to have happen depended on first getting the videotape before those things could happen. So the trial court, as in State versus Carter, was trying to be sure that the defendant understood and could place the source of his frustration properly. And that is an appropriate response. In State versus Carter, the defendant there used words, equally apparently claiming and asserting a right to be pro se. The defendant there said twice, I'll have to represent myself. And the Carter court said that was not a clear and unequivocal request given the circumstances, given what seems to have been motivating that. It didn't have the indicia that we see in other cases of, for example, a written motion citing to practice book rules. It didn't have the indicia of this being something that was deliberate and consistent. And I would disagree respectfully with opposing counsel's claim that this court and any reviewing court, in order to assess the trial court, the reasonableness of the trial court's actions on May 4th, cannot look to what happened after that date. And one example that I'll give in terms of looking at the totality of circumstances to see how this played out as evidence of whether the defendant really did mean this and want to give up his right to counsel, or whether this was just amusing or a statement of frustration. In State versus Pyers, our Supreme Court, this
Attorney
is
Feldman, would you
310
just
Con
say
at
that?
2.
Attorney Feldman, I didn't hear the name of the case. Could you just state that again?
Yes, P-I-R-E-S.
Oh, okay.
State versus Pyers, and the citation, the page citation is 310 Con at 243 through 244. The Supreme Court, in assessing the defendant's purported invocation of the right to counsel, looked not only at subsequent pretrial hearings, but looked at the defendant's conduct during trial and the defendant's conduct during the appellate proceedings to infer back as to whether the defendant had really wanted to be pro se at an early purported request to be pro se. So it is appropriate to look at what happened later, because the goal here is not sort of a gotcha for the trial court. Like, he said words and we're going to interpret those words on appeal in a certain way and everything stops there. The goal is to make sure that this defendant wasn't prevented from asserting what he really wanted. And in this case, the trial court made it abundantly clear on more than one occasion how the defendant could assert this interest if it was his genuine interest. On the May 4th occasion, the trial court told the defendant that he could reassert the right and that they would wait just a week and see what happened. He did not reassert the right until months later. And at that point, he asserted the right after having come into court saying, I need new counsel. And he asserted it in after a discussion of how he could get new counsel by filing a motion, and he asserted it in the context of a conversation about whether he should be penalized for his misconduct with the marshals coming to court. So again, this is not a clear and unequivocal request. When he asserts mutually inconsistent interests in new counsel, his lead-off request, and then says, and I also never got my pro se request considered. And there's also, a question of why he was really raising it at that point, whether it was strategic deflection from being not allowed to attend court in person because of his misconduct. But the court, again, did not close the door.
Attorney Feldman, Judge Suarez has a question.
I'm sorry, I have to say I don't see the hands when they come up, so thank you for letting me know.
Okay, thanks. So didn't this defendant ultimately acquiesce to new counsel?
He did, Your Honor.
Yeah.
He he filed a motion saying that he wanted new counsel. And the trial court held a hearing. The defendant said it would be acceptable to him to get new counsel. He specified particular counsel he didn't want, and the trial court accommodated that and gave him different new counsel, and he never again complained about his representation.
Well, he was satisfied with that, right?
He didn't indicate any lack of satisfaction. Now, I will agree with opposing counsel that in a case where the defendant had clearly indicated that he wanted to be pro se and the court refused to consider that request, that's not this case, refused to consider that request and instead appointed new counsel, the fact that the defendant may have thought that he simply couldn't be pro se and had to accept new counsel. But that is not this case. When the defendant again indicated that his pro se request had not been considered, the trial court told him that he could file a motion to renew the request to be pro se. And this defendant knew how to file motions, and he waited 9 months, and then he filed a motion called a motion for appointment of new counsel. He also filed other letters and motions at that point, and a couple of them referred to his right to be heard by himself, but always in the same breath as his right to and interest in having new counsel. And so, again, there was nothing clear or unequivocal. He had been instructed on how, if he was serious about it, he could pursue an interest in being pro se, and he did not do so.
And Attorney Feldman, you have 5 minutes. You may not have seen the sign.
Thank you. I did not. Thank you. I appreciate it. My screen is, in addition to my bad vision generally, my screen is in a funny way right now. So,
okay. All right. Judge Cradle has a question.
Thank you. I do have a question. Wasn't it demonstrated in the record also that he made claims in written motions that then later on the record he agreed that he didn't necessarily wish to assert or didn't mean because he was claiming sleep deprivation among, other things?
That was one instance where he made threats against his attorney in a letter and said he needed new counsel, and if he didn't get new counsel, his attorney was in physical danger. And when the court expressed real concern about that, he said, I'm sorry, I didn't mean it, I was sleep deprived. So that was one of the instances that I was referring to earlier when I said that this is a defendant who showed that he did things spontaneously and that he later regretted. And to act on any one burst of emotion of his or burst of frustration of his would have been really unfair to him and a mistake. There was another instance that I was alluding to earlier where he got in a fight with the marshals on the way to court. And later, when the trial court threatened that he would not be able to be in court, he apologized for that and, said that he should not have done that. So again, this was somebody who was temperamental, and the trial court handled this taking into account that a defendant in a pretrial proceeding, the May 4th request was the 5th out of 35 court dates. The defendant was frustrated in ways that, he may not have known what he was asking for or getting into if he just said, I want to proceed pro se. And the trial court took it slowly, as it should, and gave him opportunities to reassert that if that was a passing interest and not like his sleep-deprived threats to his counsel or other, temporary sort of dramatic things that he asked for. Opposing counsel contends that Braswell, State versus Braswell, controls this case. And I just want to suggest that Braswell is a study in a contrast to this case, where in Braswell, the defendant filed a written motion to be pro se. He refused to come in the courtroom if his defense counsel was there. He repeatedly told the judge that he would not do what the judge suggested was coming next because he wanted to be pro se. The judge asked him if he had backup counsel ready, and he repeated if he had substitute counsel ready, and he repeated he wanted to be pro se. And then the trial court in that case just shut the door on the request, saying you can only raise this again if you have something more to give me. And that was not this case. Your Honors, I think I just have a minute left. I know that opposing counsel is focusing on the first issue. I just want to say with respect to the second evidentiary issue that this review of this issue would be the classic ambuscade on the trial court. And I urge you to read the long colloquy the trial court held with the attorneys. It is a model of cooperation and agreement in which defense counsel conceded relevance but had 3 concerns about the evidence, and the trial court satisfied each and every concern of the defendants, and the evidence came in exactly the way that defense counsel indicated would not be objectionable. So to review this claim would simply be to overlook the efforts that the trial court went to, painstaking work to reach an agreement among the parties. And finally, State versus McLean does not apply to express waivers and say that notwithstanding an express waiver, this court can review a claim if the defendant labels it plain error. McLean has to do with the interplay between the Kitchens doctrine and plain error. The Kitchens doctrine involves implying or inferring a waiver on a record that is silent as to a claim. And in McLean, the court said that it would not infer that counsel who said nothing about a particular issue would have waived an issue that is plain error. But there's nothing silent in this record. Defense counsel asked for and agreed to the changes that the trial court made to make the evidence acceptable to him. If there are no other questions, Your Honor, the state respectfully asks that you affirm the judgment of conviction. Thank you.
Attorney Hamilton.
Thank you. So I would like to respond to a couple of the state's points. One being, in Braswell, and again, this case is controlled by Braswell. And if we look at page 835 of the Braswell case, the court does note hypothetically that the defendant's conduct following the denial is irrelevant to the question of whether that denial was improper. So if we look at the May 4th denial, his behavior at subsequent hearings is irrelevant to the trial court's consideration of that initial request on May 4th in determining whether or not that request was clear and unequivocal. While the trial court does have, the discretion to explore once there is a clear and unequivocal request, that it is a constitutional right. And we see in Ferretta with the United States Supreme Court that it is clear that it is the best situation for a defendant to have an attorney, but ultimately there is a constitutional right to represent yourself, and if it's asserted clear and unequivocally, there's no, it's the defendant's mistake to make, for a lack of better words.
So counsel, if I may, in terms of the determination, you do agree, do you not, that in determining whether or not whether the canvas is to be asserted, there is some degree of discretion for the court. Is that fair?
Yes.
And that's what the state's position is. So you agree that there's some discretion in determining whether the canvas is triggered?
Yes, there's discretion in determining whether it's clear and unequivocal, but once it is, there's no discretion. And
so how does the court determine that? How does the court exercise its discretion, and what factors do you dispute that Attorney Feldman raised as being appropriate for purposes of that exercise? So,
the state had, discussed Carter, and in Carter, the defendant states, I'm misrepresented, now I need to represent myself, or I'll just have to represent myself, and that was found to not be, a clear and unequivocal request. However, in this case, even though on the May 4th denial or the request, he states, I'd like to proceed pro se. It can't get any more clear than that. And the circumstances surrounding the request include trial counsel also understanding that his client would like to proceed pro se, informing the trial court of that, and then the trial court discussing other matters. In a similar situation in Jordan, the defendant had asserted it was a motion to proceed pro se as well, or he asked for alternative. If I can't have new counsel, then I'd like to proceed pro se. And ultimately, the trial court addressed the motion for new counsel, finding it unsubstantiated, and then didn't, address his request to proceed pro se. And that was found to be an insufficient and improper way to handle that situation by the trial court, even though there were two requests on the table at this point. However, that case is distinguishable in a sense, because on the May 4th proceeding, the only request in front of the trial court was the request to proceed pro se. There was not a request for new counsel. There was not a request for anything but pro se. In addition, in Pires that the state had referenced, which is a case we talked about in our brief as well, and a case that Braswell goes through, the trial counsel tells the trial court, my client would like to proceed pro se, and then once the defendant appears on the record, he remains silent and doesn't say anything, even when trial counsel explains to the trial court that she had explained to the defendant that his request was likely to be denied. And ultimately, that request was found not clear and unequivocal because of the defendant's silence. But in this case, you have the defendant coming out on the record and reiterating what trial counsel explained already to the trial court, that I would like to proceed pro se, and it's denied, yes, without prejudice. However, it's clear that the record following that, that the defendant understood that he was being forced counsel, and if he's asking for the appointment of new counsel, and again, while the titling of his motions suggests that he's asking for the appointment of new counsel, he's consistently throughout the entire record is asking to represent himself, and clear that his request is being wrongfully denied.
Counsel, I believe that your time is up. So I want to thank you both for your excellent advocacy on behalf of your clients. Very, very well done. I also want to thank you for your patience with respect to some of the technical difficulties that we've been having, I specifically, and I appreciate that. That didn't seem to disrupt either of you at all. And we will appreciate also your making the accommodations to argue on remotely and making that effort. So we will stand in recess and take this matter in under advisement. And again, thank you very much. We'll stand in recess until 10:30. All right. Thank you.
Thank you, Your Honors.